Hey guys, I just wanted to jump on here real quick and talk about non-competes. Basically, an agreement between employer and employee restricting the employee from competing with you once they leave your employment. So, employers invest a lot of time, training, showing process, trade secrets, client lists, all sorts of things to employees when they are training and when they are in your employment. And so non-compete will prevent your employee from leaving and taking all that with them when they leave. And usually they leave and then form their own business, and you're worried about them taking your client list or any other secrets that you might have. So you want to make sure your non-compete has at least these 5 basic things. One, you have to have your specific business or industry noted in there. What specifically can they not do? What business is it? What industry is it? Or if it's a specific employer, what specific employer can they not go work for? So Boeing probably doesn't want one of their employees going to work for Airbus right away after they leave their employment. 2 is time limitation. You can't make these last forever. So typically 6 months to 2 years is going to be enforceable. Courts are not going to uphold an unlimited non-compete because you can't prevent people forever from going out and making a living. 3 is scope. What can that former employee do and not do? And it should be spelled out. If it's not spelled out, it's vague and it's going to be generally unenforceable. So the courts can't enforce something that's not clear. So you have to spell out exactly what they can and cannot do. 4 is geography, so specific to your location, and I mean really specific. You want to have where you do business listed and any radius in mileage around it that's reasonable. You have to define that. Again, otherwise it makes it vague and unenforceable. 5th is penalty. So what happens if this gets violated? 1, you definitely want, an injunction order, the ability to have the courts order them to stop doing what they're doing if it violates the agreement. Then you want to wonder, do you get punitive damages, liquidated damages, actual losses? If you can prove an amount that you're out because of this violation, you want to put that in there. So these are incredibly specific to your business industry, geographic area, and specific circumstances surrounding your actual situation. So I don't really recommend you go out and just get a general non-compete. You want it to be enforceable, otherwise it's not worth the paper it's written on. So in your jurisdiction, if you get a general non-compete that's too long, not specific enough, it's not enforceable and you've now wasted money. Consult with a lawyer who knows what the courts are going to uphold in the event of a violation. I hope that was informative, and thanks for listening.